Well, good afternoon, everyone. On behalf of the Alameda County Bar Association and the League of Women Voters, we'd like to thank the candidates for taking time to participate in this forum and welcome you and the audience to this highly anticipated event for the Alameda County District Attorney's Office special election. I'm Charles Woodson, serving as your moderator tonight, and our goal is to provide the candidates with a nonpartisan forum for a civil discussion about their policies and priorities that will impact Alameda County. Alameda County is at a pivotal crossroads. After a period of historic transition, voters are once again being asked to choose our top law enforcement officer. The person who holds the office yields immense power, directing a budget of over $100 million, managing over 150 attorneys, and working with every law enforcement agency in Alameda County. Tonight, we will hear from Pamela Price, Ursula Jones-Dixon, and Gopal Krishan. The rules of the forum are clear and have been agreed upon by all campaigns. Time limits will be strictly observed using with our timekeeper, and the candidates are expected to stop speaking the moment their time expires. We look forward to a civil and lively discussion. Thank you. So at this time, I'm going to ask Mr. Krishan if he would like to give an opening statement.
Thank you, Charles. You can call me Gopal. Sure. And happy Friday to everybody. Today is Friday. It's a very good day. And I would like to thank, before I start, Ocean. He arranged everything, and it is very hard to bring each and every person on the table at the same time. And I would like to thank the Alameda County Lawyers Association, sorry about that. Lawyers Association and the League of Women Voters and Charles and fellow candidates to be here. It's a great opportunity. With that, I would like to start my opening statement. I know my time is running. I'm a person, my name is Gopal, and I am a person of humble beginning. I came from India with almost nothing in my pocket, with dreams and with a willpower. Came here, studied for the bar exam. My lovely wife supported me during the whole journey. She did 5 jobs. She helped me, she's still helping me. She's here, right here. And I started I passed the bar exam, started my own law practice, got married. I'm a proud father now. In the whole journey, I'm representing the families, I'm representing the businesses, and I have seen that what is missing in it. I have talked to the families. They are scared of ICE. They are scared of the hate crimes. And I have seen the businesses, they close down because of the organized crime. And I'm not seeing that anybody in the whole county is doing anything about that. And that is concerning. And I'm not seeing any hope in it. I am that change. I want to be that change. That motivates me to do something for this county, for our community. And that's the reason I'm here. I have 3 main priorities, very clear priorities. No ICE. There should be no fear of ICE for the Alameda County residents. There should be no hate crime in Alameda County. We are better than that. We are people, we are civilized people. There should be no hate crime. When we tolerate that, we basically promote that. And the third, I will be tough on organized crime. It doesn't hurt our families. It hurts our businesses, and it takes away the hope from us. That hope kills the American dream. We deserve the safety, public safety. We deserve everything in our county. And that's the reason I'm running for the district attorney. And I appeal to everybody, if that relates with you, please vote me, support me, and help me.
Thank you.
Thank you.
Ms. Price?
Good afternoon. My name is Pamela Price, and I'm honored to be here and appreciate that the organizers have brought us here today. Let me tell you a story about why I am qualified, the best qualified person to serve as our district attorney. I'm a survivor of the juvenile justice system. I'm a survivor of sexual harassment, of sexual assault, of domestic violence, and vindictive prosecution. I was arrested when I was 13 years old in a civil rights demonstration and tracked into the juvenile justice and the foster care system. I literally made it from the streets of Cincinnati to Yale College by the grace of God. I got a great education at Yale, and I came to California to go to UC Berkeley Law School. While I was at Yale, however, I walked into Professor Raymond Duvall's office to turn in a paper as a sophomore at Yale. I went to turn in my paper in political science. I slid the paper under the door. Professor Raymond Duvall opened the door and invited me in. And while I was in his office, he asked me if I would sleep with him, he would give me an A, and if I refused, he would give me a C. I said no, and I got a C. And a year later, I joined Alexander versus Yale, the first sexual harassment lawsuit under Title IX. And because of my case, women everywhere, students, every educational institution is required to investigate claims of rape, sexual assault, and sexual harassment. In 1980, as a law student, I co-founded the Bay Area Defense Committee for Battered Women, challenging the patriarchy here in Alameda County, coming to court here. In 1981, I found myself in an abusive relationship and myself was arrested, and then I was prosecuted by this office, the Alameda County District Attorney's Office, as a victim. It was my honor, however, to serve as the 30th elected district attorney and the first non-appointed elected district attorney in this county since 1938. In my first term, we partnered with law enforcement agencies to tackle gun violence, human trafficking, wage theft, and crimes against women and children. We processed cases at a higher rate than my predecessor. We expanded and improved services for victims by hiring a more diverse workforce, hiring more advocates, and reducing backlogs and ensuring that people had access to mental health services and support. We went after corporate criminals and landlords and rogue public officials and police. We received millions of dollars in grants and received over $20 million in judgments and settlements our first year. We did not finish the work, and that's why I'm here, because there is much work to be done, and we need to get Alameda County back on track as soon as possible so that we can finish the job that you all elected me to do. Thank you.
Thank you. Ms. Jones-Dixon.
I'm a little taller, so I hope you all can hear me. I don't want to sit while I address you. I'm Ursula Jones-Dixon, Alameda County District Attorney. I want to first start by thanking the League of Women Voters and the Alameda County Bar Association for hosting this great opportunity for us to have these conversations about public safety in our county. I was a deputy district attorney at Alameda County for about 15 years before I was appointed to the bench to serve as a judge, one of the greatest honors of my life, for 11 years, and that was by Governor Brown, Jerry Brown. After 11 years and after the recall, people stepped up and asked me to think about becoming the DA in this county. And I want to be really clear, the only reason it's necessary for me to have been appointed is because of the recall. Now, I say that because I think it's important to talk about what this office requires and what victims of crime desire and require. The only reason I'm in this position is because I believe that victims' rights actually mean something. In fact, they're in the California Constitution, for those of us who don't know. Defendants are not the only ones who have rights. And so that equation is very important. This is a holistic conversation about everybody having the opportunity to be heard and to be respected in the criminal justice system. Victims' rights are of utmost importance to this community, as well as public safety. And public safety is, in fact, a public right. Everybody has a right to be safe within their communities, no matter where they live, what they look like. And so our goal at the Alameda County DA's office now is to rectify everything that has been upside down, starting with the fact that victims' rights will be respected. We will be heard. Victims of crime will be heard. Secondly, we are bringing back people to this office who actually are prosecutors who understand how to do the work so that we don't find ourselves in situations where cases are dismissed, individuals don't get a chance to have their case heard in court because their cases aren't charged. So we are working our way through all of those issues, whether they be backlog cases not charged, whether they be institutional knowledge that we need to bring back to the office. I need you to know that this is an office that's about public service. Our only goal is to make sure that we keep victims at the center of the job that we do, and we do it fair and impartially. I'm best qualified to do that because I've done the job. I've been a DA, I've been a judge. The courtroom is my home. And I will make sure that we protect victims in this county. Thank you.
Thank you, Ms. Jones-Dixon. Now, Gopal, how do your policies and practices best reflect the values and priorities of Alameda County?
When we see the Alameda County, we see people, we see the beaches, we see wineries, and we see small businesses. This is what Alameda County is. We are small, hardworking people. We have teachers, we have doctors, we have engineers, we have immigrants, we have non-immigrants. It is a diverse community. And as a person of color and as an immigrant, I feel it that I represent my values. The three priorities I gave in my opening statement, they reflect the value of this community, this county. 1 in 3 person is a foreign-born citizen. That's the data suggests. So the Alameda County is a home of immigrant, and it welcomes each and every person with open heart. It is not for politicians. It is not for the dirty politics. It is not for the organized crime. It is for the sweet-hearted, kind-hearted people. And I think the people, they are taking it for granted. We are being a victim as an Alameda County resident. From the ICE, we have to live in the fear of ICE, and I don't see any policy by any district attorney office. We have the district attorney office for a long time. I don't see any specific policy. So each and every, I represent those people, and I can see the fear in their eyes. Even if there is no real incident, fortunately, I think the fear is very real. And as an immigration lawyer, I see that and I feel that. The second is the hate crime. I talked to one person, and she was talking that one of his friend got stabbed in the bar because of his appearance. Nobody deserves that. Nobody deserves to be stabbed, thrown on the ground the way they look. As a person of color, it is personal for me. I've been a victim of hate crime, nothing happened. So this is extremely personal for me. I will stand for that. I will be punishing all the criminals for the hate crime when I'm gonna be the district attorney. And the last part, the organized crime. We have good neighborhoods. We have businesses. We have seen the break-ins in the car, and we take it very lightly. Somehow it is very normal nowadays that if we leave our car in the driveway and somebody is doing, not just one car, a group of the person doing it, we take it for granted. That's not who we are. We have to take an action. We have to recognize that, because if we don't even identify the problem, we cannot resolve that. The current district attorney office is not doing anything about the organized crime. They are ignoring that. Ignoring is not a solution. I am the solution.
Thank you. Ms. Price, would you like to respond? Your rebuttal, I guess, would be, is that correct? No? Okay, never mind. My apologies, go ahead.
The question is how do my practices and priorities reflect the values of the county, correct?
Correct.
All right, thank you.
Yes.
Okay, hope my time is starting again. In October of 2021, I met with a group of high school students at the Oakland School for the Arts. And they were asked, what are the most important challenges or issues in Alameda County and Oakland that, in terms of the police and the criminal justice system? Their unanimous answer was racism and racial bias by police. Our priority has to be to create a racial reckoning in the Alameda County criminal justice system. Black people in this county are 20 times more likely to be incarcerated than a white person. A Black child is more than 18 times more likely to be detained than a white child. Black children are only 12% of the population, but they are 53% of those who are all juvenile felony arrest. In 2014, the only children charged as adults were Black or brown. In 2025, nothing has changed. Same statistics, same impact. Recently, a Black man was kidnapped off the streets of San Leandro by 3 police officers and dumped, their words, into Oakland because San Leandro has always been a sundown town, and nothing was done about that incident. I believe that we have anti-racism as a value in this community, and that it's a priority for us to address the new Jim Crow in Alameda County. In 2012, 78% of us voted against or in favor of Prop 36 to modify the 3 strikes laws. In 2014, 74% of us voted yes on Prop 47 to reduce criminal penalties. In 2016, 77% of us voted yes on Proposition 57 to stop prosecutors from charging juveniles as adults, and 66% voted against the death penalty. In 2021, it was our state senator, Nancy Skinner, who sponsored SB 81 to eliminate the use of enhancements. That law went into effect in 2022, and in 2023, my administration put it into effect. We issued the special directive. As district attorney, we have to train prosecutors on the Racial Justice Act, which we were doing, and SB 81. We have to embrace colorblind charging guidelines that have been issued by the California Attorney General last year. We have to embrace SB 60, which requires prosecutors to notify victims and survivors of their right to community-based restorative justice programs. We will use our discretion to resentence people serving excessive sentences and partner our resentencing program with a robust reentry program to ensure that public safety is protected. Thank you.
Let's not have that at this time. And Ms. Jones-Dixon.
Thank you. So as it relates to policies and practices that reflect the values of the community, it's clear to me that the values of our community are very supportive of victims' rights. It is also clear to me that the values of our county are very supportive of public safety and ultimately being a good steward of the county's money and making sure that we take good care of this office by not using our money inappropriately. I want to just kind of speak a little bit about what the values of the community are. The last passing of Prop 36 clearly indicates that the community has changed their position a bit on theft, but also continuing to focus on treatment. I should say about Prop 36, and I think we all should say that, it's an unfunded mandate. The state has never given us money for it. And so it is complicated for a district attorney's office to follow what the voters are asking us to do, yet not to have funding for it. I would also say that as it relates to juvenile justice, I spent 11 years as a judge, 10 of those in a juvenile court. I can tell you that it is a fact that the DA cannot direct file a juvenile case. The DA can't send a juvenile directly to adult court. What the DA can do, and what has been done under my administration and the last, is file a petition to ask the court to take a look at the history of a child to determine whether or not that child can be rehabilitated in the juvenile system and how. Not just that they can, but and how. And actually, as a juvenile court judge, I knew that was my job to do. That's what the statute requires that we do. And as a result of that, I think we need to get real about the fact that within our community, there are wish lists of all of us wish for public safety. All of us wish that victims' rights were supported, et cetera, but we have to work to get there. And we cannot be as simplistic as to believe that the district attorney's office does not have certain mandates. We have things that we're required to do. So when we talk about the community being supportive, I would just say of the practices and policies that overwhelmingly there's support across Alameda County for this district attorney, Ursula Jones-Dixon. You can look at the endorsements and see that. The reason is because we are working very hard to do the work that the DA is supposed to do and to re-educate people about what the district attorney is supposed to do. It doesn't mean that we have one job to do. It means we have certain mandates. I really hope for a time where people can have a conversation about the DA's office not being political, not being agendized, but being an elected office.
Thank you. Ms. Price, actually, it'd be Gopal. Would you like to rebut? You have 30 seconds for a rebuttal.
No, I don't have any rebuttal.
Would you like to, Ms. Price? You can go ahead if you.
There was a mention of the referral of juvenile cases under my administration. The only time we referred a case to adult court or asked that it be transferred was after a negotiated settlement. And it was a strategic move that was negotiated with defense counsel because we had a number of cases where young men were sentenced as adults or they were juvenile sentenced as adults. They came back to us and we had a whole group of cases that we had to figure out how do we protect public safety and resentence these young men.
Ms. Jones-Dixon.
I can only tell you what the statistics say, what the data says. Both of our administrations have filed petitions to the juvenile court to ask the juvenile court to take a look at juveniles, not adults, to determine whether or not they should be elevated to adult court. And that is because it was a serious and violent felony, and we wanted that information. I'm assuming I can't speak for Ms. Price. I want the information.
I do have a brief follow-up, though.
Sure.
You had mentioned the budgetary constraints. You had mentioned the budgetary constraints with Prop 36 about treatment, while at the same time, in juvenile court, filing the petition, which inevitably costs the courts a significant amount of money to review those petitions. How do you reconcile the funding in one aspect, whereas in the separate aspect, it appears that there's a funding firewall?
I think that what's missing is it's a mandate without funding from the state. What the court has funding for, judicial council, is different than what the state is funded for Prop 36. In addition to that, when we talk about expert witnesses for juvenile cases, probation starts that process. They write the first report. They are employees of Alameda County. If we go out and ask for secondary experts, that comes out of the DA's budget or the defense attorney's budget. We're talking about state funding for treatment, whether it be for drug treatment or any other type of treatment. That's different.
Thank you. Okay. Ms. Price, we're going to move on to the second question. As the head of an agency with around 150 attorneys, how important is it for the elected district attorney to have prior experience managing a large office?
Prior experience managing a law office, a large office, definitely helps and is one piece of the puzzle. Experience in any operation always counts. Longevity also matters, however. When I started my practice in 1991, I wrote my first personnel manual and hired my first employee within months. Over my 30 years of private practice, I hired hundreds of employees and helped dozens of other companies work on their operations. I successfully managed executive teams to run my law firm and achieved major victories. We managed legal teams across the country and litigated cases against some of the largest law firms and law departments in this country. We beat Amtrak. We beat the United States Postal Service, and we beat the state of California over and over again. We designed and administered major consent decrees. I was the court-appointed monitor for Contra Costa County's Equal Employment Opportunity Program for 14 years, and I participated in the design and Freetag versus Ayers of a statewide injunction to protect women working inside the Department of Corrections. In 1997, I ran 2 offices as the interim executive director of the San Francisco Lawyers Committee for Civil Rights, supervising a staff of about 40 people and coordinating hundreds of pro bono lawyers through San Francisco law firms. More importantly, every office requires a team to run efficiently. I brought an amazing team of 11 people into that office when I became the district attorney. Chief Royal Roberts has a doctorate in business administration and 25 years experience managing top or large organizations. He was the chief counsel for the Peralta Community College District, which has more than 2,500 employees. He was the chief of staff to the chancellor, the HR director, and the director of diversity programs. Chief Assistant Otis Bruce had 32 years of prosecutorial experience, including more than 3 years as a chief assistant district attorney. In Marin, it was a smaller organization, but it was still a comprehensive experience under multiple district attorneys. Cynthia Chandler, a person associated with this bar association, who is the recipient of the Faye Stender Award. She co-founded multiple social justice and legal organizations. She was an associate director and law professor. She's the director of this bar association's Valley program. Chief Eric Lewis, a former deputy chief at OPD with 30 years experience. Christina Molina, 17 years experience serving victims, managing hundreds of volunteers and staff. Our head of Consumer Justice Bureau was a brilliant litigator with 30 years experience. So we had a great team, and we came into an office that was disorganized, demoralized, and woefully understaffed. Thank you.
Ms. Jones-Dixon.
Thank you. So it is extremely important to have the experience of both a prosecutor and someone who's run an organization to do this job. As previously stated, the budget is over $100 million. We have over 400 employees, over 150 lawyers, and there are special requirements for prosecutors. They have ethical requirements that no other attorneys have. So it probably explains a lot of the missteps that we saw under the last administration, because a lot of the folks there did not have that experience level. I can just say that there were absolutely budget issues when we walked into the door. $2 million owed to the state, $80,000+ that had not been paid. We were being sent to collections. We also had a situation where we had attorneys who were not providing discovery to lawyers, to defense lawyers. That was exculpatory, meaning that it pointed toward evidence. And as a result of that, 3 of those lawyers under the last administration in a hearing took the stand and invoked their Fifth Amendment privilege against self-incrimination. I've never seen that happen before to a district attorney. We had a consumer division that hired lawyers. We're a unionized shop here at the DA's office. These DAs are unionized. But the past administration hired lawyers, civil lawyers, to do the work of DAs who were being paid, and there was a fee agreement in place to pay those lawyers for the work that they had done. There were so many missteps that included a backlog of so many cases. I've never seen this amount of backlog. Let me tell you what that means. Many individuals who were victims of crime did not receive their day in court, did not have their cases charged because the cases were too old to charge. And in fact, one of those was fairly public in the media. So I'm telling you that experience counts at the district attorney's office. You are required to do certain things by mandate. You cannot over-politicize a case or you get recused from it. There are many things that have happened that we need to discuss as a community, what you want from your district attorney. I can tell you experience in the job of a DA, and also knowing how a case should roll out as a judge is of import to all of you. Because when you are the victim of a crime, you want people who know how to do that job at the helm. You want people who know how to charge a case. You want people who know how to try a case. You want people who know how to divert a case. You want people who know how to have a relationship with law enforcement. You want people who know how to do this job. And I'm best qualified to do it.
Thank you. Go, Paul.
Thank you, Charles. So I have heard the argument and the response from both the candidates, and I really appreciate the response. But let's take a step back. We have $110 million, and we have one office to run. I run my office very efficiently. I have staff, I have marketing budget, I have to calculate the ROI in it. So when it comes to run an office, the experience counts and the good experience counts. Not just, yes, you have this experience and you can make it work. I don't see any efficiency in it. $110 million, 150 lawyers, and still the crime rate is going up. And I see the complaint about we need more money, we need more money. It means There is no leadership in the office. There is no efficiency in the office. There is no direction in the office. This office in the same direction will do the same thing over and over again. I don't see any clear insight in it. We need to make sure the return of investment. $110 million is a huge money. It's a taxpayer's money, and district attorney office is responsible for that. The aim is not to get more money. The aim is to make it efficient. We have the caseload from the previous administration. We have the caseload going up. The deadlines are missing up. There is no accountability for that. The district attorney office has to work on that. I am running my office with very high efficiency with great return of investment. I have marketing budget, I have hiring budget, I have the contingency budget, I have budget for everything, and I have plan for everything. It is an operational issue. It is a scalable issue. As a district attorney, I can scale it. It is not about having 5 employees or 50 employees. If you have the 5 employees and you cannot have the 6th one, it means you are not a good boss. You have to have a vision. You have to have the leadership qualities so that you can manage your own office. It is your office and you're responsible for that. You should not be complaining, I have less money. You fail, you should be fired. This is what the district attorney needs, a change, a system, and efficiency, which I can provide.
Thank you.
Thank you.
30 seconds rebuttal, Ms. Price.
Sure. Yeah, I think it's very important that folks should know the 3 lawyers that took the Fifth Amendment did so because this office accused them falsely of criminal misconduct long before they were ever talked to or asked, and they were never given an opportunity. Well, when they were given an opportunity, by that time, the office had already attacked them and filed documents with the court suggesting that they had engaged in criminal misconduct, which I found very offensive, and those lawyers were all very good, experienced lawyers.
Thank you.
Okay.
Ms. Jones-Dixon.
I think it's fine to talk about managing offices, but you also need to know what the penal code is when you're going to be a district attorney. You need to know what the job is. And so we can talk all day about a budget we know nothing about, but I'm telling you, I'm in budget season right now. It's no fun. You need to know a little something about it. And secondarily, nobody invokes their Fifth Amendment privilege against self-incrimination unless they feel like they're incriminated. They've done something wrong. So from that perspective, I've never seen a DA do it. I hope to never see it again.
I would say, though, that everybody's presumed innocent, correct?
Absolutely.
Do I get?
No, Gopal gets to respond if he likes.
Okay.
Yes, it is the question you were. Thank you. The question you were asking is about the experience to manage 150 employees.
Correct.
And for that point, yes, it counts, and it has to be with efficiency and the leadership. It is not about the criminal. It is an operational issue. If we are making it legal, we're not going to succeed.
All right. Well, we're going to move on to the 3rd question. Pardon? I don't believe so. 1 rebuttal. So the 3rd question, Ms. Jones-Dixon, is Prop 57 shifted the ultimate authority to transfer a juvenile to adult court from the prosecutors to judges. But your office acts as a critical gatekeeper by deciding whether to file a transfer petition in the first place, looking strictly beyond the seriousness of the offense itself. What special factors, criteria, or scientific consideration regarding adolescent brain development will your office use to determine that a youth is truly beyond the rehabilitative scope of the juvenile justice system and should be tried as an adult?
So a couple of things. One, I'm not a psychologist or a psychiatrist. I don't have the expertise to make that determination. What I do have is the authority to ask the court to request that we receive information, and our goal is to do that on all murder cases. We receive information from the probation department that includes what is this child's history, their history in their home, their history in their school, what are the mitigating factors that we should be aware of. whether or not this child is rehabilitatable in this system within the period of time that they have to be in the juvenile justice system, the gravity of the crime, and again, we're only dealing with the most difficult case. I think that's important because, again, we don't have the expertise to make that call. But in addition to that, the court has a job to do, and we are dealing with victims' families as well. When you've lost a child and you come to the district attorney's office and ask them, why is this child not going to spend any time in custody? I want to have that information available to me so that I can speak to that victim's family about how we're going to move forward. I think that it is short-sighted to believe that information is harmful. All we're asking for at the DA's office is that social studies report. And as previously stated, that has been done under the last administration and the administration before for minors, not adults coming down from adult court who were tried as minors before. Now, I think that it's important to realize that the expectation, the law is what it is. The court looked at this issue and decided the DA should not have that authority. I actually agree. I don't think we should be able to direct file cases on juveniles. But as an old juvenile court judge, I do think that the court has the ability to receive information, to order that information be brought to the court, and to help make that determination. To date, after over a year in this position, not one child has gone to adult court. Have we asked for reports? Absolutely. Does that often help us to negotiate that case? Yes. Does it help us make a determination that this child is better in a juvenile court and what services are necessary to make sure that child is rehabilitated by the end of that term? Absolutely. And that's what we're doing now.
Thank you. Gopal.
Thank you. That was a long answer. It's a long question.
It's an important question.
And it's an important question. I totally agree with you. So when we talk about the Prop 57 juveniles and as a gatekeeper, we need to see the district attorney office is responsible to make that recommendation. And the scientific facts, now we have the data available because of the technology and because of the advancement in the technology. But we have that kind of understanding, and that's the reason there is a juvenile system. That's the reason there is an age group, because we need to see the maturity of the person who is doing it. So when we see a crime and it says, okay, irrespective of the type of crime, so you need to see the person who has done the crime is a minor, obviously. Is a crime of passion or is a crime of planning? So that's one factor we can see. We can see, okay, is there any other additional factor in this? Is it a gang activity? It's a drug-related activity? Do you have any organized crime activity? Do you have any repeated offenses? So these are the factors we can see into any case. And when, as a district attorney, I have these facts, I can make a determination to ask the court, yes, this person is mature enough, or no, it is not mature enough. It should be treated as a minor or should be treated as an adult, should be charged as an adult. And we can also consider the mental health. We can also consider the drug health to make sure, is there any possibility of the reform in that as well. Not each and every child is same. Not each and every crime is same. We have seen kids 7.5. We have seen kids 17.5. And in between, we cannot have one rule for all. One rule for all is not justice. As a district attorney, it is a very good power that district attorney get to decide how to deliver justice without being biased, based on the case-to-case facts, irrespective of the actual crime. These are the factors which we can see in any case. And on the basis of that, my administration will make the simple policy that, okay, if these factors are available, this is what we're gonna do, and this is what we not gonna do. And that gives the efficiency in the office. So I'm gonna bring that clarity and transparency in the office. Thank you.
Thank you. Ms. Price? It's the third question. So Prop 57 shifted the ultimate authority to transfer a juvenile to adult court from prosecutors to judges. But your office will, as a district attorney, it still acts as a critical gatekeeper by deciding whether to file a transfer petition in the first place. Looking strictly beyond the seriousness of the offense itself, that is the code section violation, what specific factors, criteria, or scientific consideration regarding adolescent brain development will your office use to determine that a youth is truly beyond the rehabilitative scope of the juvenile justice system and should be tried as an adult.
Thank you. I think it's important that we don't rewrite history. Prop 57 was passed by the voters to stop prosecutors from abusing their power to charge juveniles as adults. That was a fact, and it was happening in Alameda County as well as other counties around the state. A prosecutor doesn't just ask the court to give a report. A prosecutor files a petition now and asks the court to transfer this child to adult court. You can get the probation report without making that request. And in fact, we did that under my administration. Probation will look at any child and give you a social study report without requiring a petition to transfer that child to adult court. And make no mistake about it, the DA is advocating for a juvenile to go to adult court. Criminologists have documented the devastating impacts of incarcerating minors as adults. Placing a minor in an adult prison creates a greater danger to public safety by increasing their post-traumatic stress disorder and increasing the likelihood of recidivism after incarceration. When you incarcerate a child, you are making someone who is most vulnerable to sexual assault and exploitation inside the prison, manipulation for criminal activities, and limited opportunities for rehabilitation. Brain science has documented 4 primary areas driving youth violence, which improve as youth mature into their mid-20s. Number 1, impulse control. Number 2, emotional regulation. Number 3, delayed gratification. And number 4, resistance to peer influence. Studies have shown that most people age out of crime by age 25. This is evidence-based criminology. It's not based on how you feel or what you think or what, you don't have to be a psychologist to know this information. It is available. The American Bar Association recognizes that from its inception, not just recently, but when the juvenile justice system was created, it was designed to protect children. That was the point. The goal was treatment and rehabilitation as opposed to punishment. And that's the context in which we operate in. There's a long history in the juvenile justice system, and particularly in Alameda County, of overcriminalizing and policing youth, especially Black and brown youth. And so youth should not be tried in adult court because it does not promote rehabilitation. It does not deter other young people from committing crime, and it imposes an immense harm on a child who then is eventually going to become part of our society. So there are no valid reasons for a district attorney to file a motion for direct transfer, in my view. And we did not do that except to negotiate. Thank you.
Well, yes, specifically to direct transfer, that doesn't exist. We just had that conversation. The DA cannot ask for a direct transfer because it doesn't exist. And the legislature looked very hard at what they wanted the law to be and made allowances for this process. Sit with the family of a child who's been murdered, or 2 children murdered by the same person. Sit with the family one time and tell me it doesn't touch you in a way that you feel like you're required to do something else.
Thank you. Gopal.
Noted.
Ms. Price.
I have sat with and represented families who have lost children. Ask Vernon Eden's mother how I stood with her. So I understand, and I'm a survivor of juvenile incarceration. I know the harm that it causes and the stigma that you put on children when they are incarcerated. And to put a child into an adult prison, trust me, Vernon Eden's mom and the mothers that I have represented for 30 years don't want to see that happen.
I have a quick follow-up question, Ms. Price. Are there any circumstances under which you would file a petition?
No.
Thank you.
We had the young people we had from that came back to us.
We're not talking about Franklin hearings.
Okay, well,
just whether or not you would, are there any circumstances under which you would
For a new offense?
For a new offense?
No.
Would either of you, Ms. Jones-Dixon or Gopal?
Thanks for the opportunity, but no.
I have the cases in my office. I've seen them. That has happened. That new petitions were filed under the last administration, not many of them, but a few for very serious cases.
Okay, we're gonna move on to these are the faster questions, where it's 1 minute and each candidate has 3 rebuttals for the remaining questions. So I guess it would start with Gopal.
All yours.
All right. So implicit or unconscious bias is everywhere. Alameda County has a diverse racial and economic population. What challenges does a prosecutor's office in this regard, and what safeguards should be employed to identify and eliminate bias in exercising prosecutorial discretion?
Just not about the implicit bias. When I talk about the biasness, I will include the implicit and explicit both, and they both are bad. It affects the decision. It takes away the dignity of a person. We are judging based on the appearance, and as a person of color, I have felt that way, and I have seen it. Many people, they don't even put their pictures on their resume because they think they're not gonna be called for the interview. One issue is we are scared of diversity. That can be handled. It's an operational issue again. We can have the training. The California Bar has the approved providers. We can have the mandatory training. In fact, for the lawyers, it is already there. We can work on that, and we can have the diverse employees in the group. So when we interact with each other, that ease up the situation. We need to know each other. This is who we are as an Alameda County.
I guess it's each person gets to answer the question as well. So we'll go to Ms. Price. You have 1 minute to answer the question.
Sure. The challenge that the Alameda County District Attorney's Office faces with respect to implicit bias is our history of explicit and implicit bias. And how do we address that? And as your district attorney, we created a special directive, which was intended to provide accountability for prosecutorial discretion in charging. We also need to initiate the training on the colorblind charging, the new law that went into effect in 2025, and implement the guidelines that were issued by Attorney General Rob Bonta. We also need to ensure that prosecutors are trained to recognize their bias and to walk away from as well under the Racial Justice Act, which unfortunately has been violated over and over in this office. And we really need to reinitiate the training under the Racial Justice Act that we started. And I need to have the person who I hired to do the Racial Justice Act training and to create that unit re-elevated because she was demoted.
Thank you. Ms. Jones-Dixon.
Sure. So the state bar requires that lawyers do training on implicit bias. The DA's office also provides that training. The legislature has spoken by saying it's race blind charging as well as RJA. So those are two things that the legislature is requiring us to do. And both of those, of course, mandates without funding, but we are making sure that we're training people and putting people in place. We just had 2 sessions of a Racial Justice Act training. So we're doing all of those things. The other piece is just that we need to see each other in one another. It's really important for us to tether to one another, because when we see someone and we see ourselves in them, we can see their experience. And sometimes it's just not about race. Sometimes it's about the human experience. And the more we do that, the better we get at helping victims through the system and making the system more fair and impartial for those who are accused.
Thank you. I do want to push back a little bit.
Sure.
Regarding your comment about having to do racial justice training and there's no funding for it, when every member of the California Bar has to do MCLEs, and those come out of everybody's pocket.
No, Racial Justice Act is what I said. That's different.
Okay. Thank you.
Mm-hmm.
But nonetheless, practitioners still have to know the law, and it's kind of a continuing learning the law, I would say, rather than a funding issue.
So the funding issue has more to do with the fact that many of the cases in this county are now being attacked under the Racial Justice Act. That was not the law 20 years ago, 30 years ago. So we are having to kind of staff up to address those issues. The training is a given. You must as a lawyer, but as a DA who's running an office, that's a secondary question. Race-blind charging is a state mandate that was not funded. So we had to come up with the money to create the technology to do race-blind charging. So although that was a mandate by Bonta, we don't have the money to do it, although we found it.
Ms. Price, would you like to
Sure.
weigh in?
We were aware when we came into office in 2023 that these mandates were coming, that they were there. We did have staff, and we did use the technology to upgrade our technology to be able to be ready for colorblind charging, to do the Racial Justice Act charging training, and to be ready for the motions that are being filed. We had quite a few motions, and we had organized a whole team of people to be able to respond to Racial Justice Act motions.
Thank you. Gopal, would you like a moment?
Yes. So as a district attorney office, when you failed, you don't have any excuse. And when you're successful, you don't need one. I see that, okay, there is a budgeting issue, there is a funding issue. I see the efficiency in the district attorney office with $110 million budget is missing. I don't see any ROI. Somewhere, somebody is spending money, not on the necessary expenses. They are spending money where the required expenses are left out.
Thank you. We'll be moving on to the next question. Ms. Price? As the top law enforcement officer in Alameda County, do you think special procedures outside of the district attorney's office should be implemented to investigate officer-involved misconduct? Should that be the attorney general, a grand jury, or other body?
So prior to my election, I supported the legislation that created the special investigative unit at the Attorney General's office for officer-involved shootings of unarmed civilians. So that is in place and was in place before I was elected. As a district attorney, I don't believe that the grand jury is, because we staff the grand jury is not prepared to appropriate to have that. And no cases, we've had cases we asked the Attorney General to take, and they said no. So as a district attorney, you have to be able to establish rigorous internal standards for evaluating police reports. You have to have your prosecutors ethically prepared to present police testimony and to recognize where there is misconduct or where there is racial bias. We have to create an open door policy for whistleblowers, whether they be deputy district attorneys or police officers, to be able to report misconduct and know that those reports are going to be taken seriously. That's why you need a public accountability unit.
Thank you. Ms. Jones-Dixon. Yeah, it's
Okay.
you because of the...
Okay, so I was just going to say that the AG does handle the cases that are unarmed where someone dies. The district attorney's office has all of those other cases. I mean, it wouldn't bother me one way or the other if someone else was doing those investigations. The only issue I would have is if the investigations are done by another party and the prosecution is done by us, right? So if, for example, another agency like the AG does the investigation, makes a determination as to whether or not this is a case that should be charged, move forward, and then sends it to us to charge, we want to do that investigation ourselves. I think that, to be honest, you know, the police cases are a mess. They're all over the place. Like, there's so many cases, so many different investigating folks across the country, and everybody's doing this differently. For us, I think it's the most important thing is just to get down to the basics and to make sure that we're following the law and to make sure we're investigating them fully. You don't need a public accountability unit to do that.
Thank you. Gopal.
District Attorney Office has a very close relationship with the police department. and that can create a conflict of interest when we have one person working for the district attorney department. There is an ongoing communication. So in case of officer involved charges, it's not about who's gonna do it. It's about the end game. Can the district attorney office do it without being biased? Can the district attorney office avoid the conflict of interest? If the answer is yes, and the investigation is fair and just, in that case, the district attorney office can do it through the grand jury. If not, then we can actually refer the case. We can get the help from the attorney general office. As long as we are clear on that the investigation is just and proper and it is to avoid the conflict of interest, we can use both the scenarios.
Thank you. Does anybody want to respond?
Does that count for 30? I know you said we only
I
had.
believe it does.
Okay.
Okay. I think we've all answered. We're gonna move on. So the next question, Ms. Jones-Dixon, I believe it's yours. Or wait, am I right? Thank you. Please describe the role restitution will play in your office if, obviously, you're currently sitting in office. But if you win the election in a few weeks. What about juvenile cases? How do you balance the concerns of low-income families against the needs to obtain restitution for victims?
So the law is really clear on restitution. We hired back a state expert in the area to come back to the office to help usher us through this. Restitution cannot be negotiated away. And so when you talk about looking at the balance between low-income families and restitution, it's not fines and fees. It's not what goes to the court. It is what a victim has lost. And the loss is generally, it can be burial fees, it can be medical fees, et cetera. We can't negotiate those away. We're required to make an order as it relates to restitution, but we don't collect on that. The DA's office is not involved in the collection of that. So we're not a civil organization. We don't sue anybody civilly to get the money. The court can ask for payment as it relates to restitution, but it does not come directly to the district attorney's office, or the district attorney's office is not collecting on it. You had a question?
So then, go Paul.
Thank you. Yes, I can answer this question. So when we talk about, this is the second question about the juvenile, and I want to make it more clear. It is not just the juveniles. It is a victim's right. When somebody is affected by a crime and there is a restitution available, it should be not just for the juvenile victims. It should be juvenile defendant. It should be for the adult defendant as well. So I'll answer that. So the difference between juvenile defendant is because sometimes they don't work, sometimes they don't have any job, and their parents will be responsible. So we cannot negotiate it down, as my fellow candidate said. It is a victim's right and it has to be there. But think about that. There is no money in it. And if you have a court order, the empty court order without no money has no value in it. So we have to think about that. Can we have any alternative arrangement on that? Can we have a community service? Can we cut down the admin fees? Is there any other way we can make the victim whole?
Thank you. Ms. Price.
Yeah, thank you. I think the issue of restitution is a very troubling one because of the balance. And it's actually, victims are being misled about restitution, because when someone goes to state prison and they are working for 20 cents a day or not working at all, they're not able to pay restitution. And if we're sending people to prison for 10 years, 15 years, the victim is not going to get restitution. The DA's office has in the past had a restitution unit that does enforce those orders, and in fact moves to revoke parole or probation when people don't pay their restitution. This is a major issue that the legislature needs to address. First, perhaps the Board of Supervisors, as we advocated on fines and fees, the Board of Supervisors were able to step in and address that issue. The legislature or the Board of Supervisors needs to resolve that, because victims are being left out in the cold when you have parents who have kids that commit crimes and they don't have the resources to pay people back. You can get a civil lawyer and sue, but that's not what happens.
I just want to follow up quickly, Ms. Jones-Dixon. It's my recollection that there was a restitution calendar in Alameda County. Has that gone away?
There's a restitution calendar, so that restitution is ordered, and we can't collect, is what I said. The DA's office cannot collect. Civil judgments can happen. You
Correct.
can do that in juvenile, as you know. And also, there's a court, because the court is required to take a look at what's happening with restitution. If there's an open case, that case is closed, and it moves on to the civil arena. But the law is very clear that we must seek restitution. And if we get an order for restitution, what happens after that is really between the person who is ordered to pay that money and either the civil court or the court that they're in front of if it's still a criminal case.
Thank you. Does anybody else want to weigh in?
No.
I'm sorry, that's just not accurate. We had a restitution unit, and prior to me, my predecessor had a restitution unit, and they go to court. There is a restitution calendar, and people go to court, and if you don't pay restitution, the district attorney will move to revoke your parole or your probation. That is what has been happening in Alameda County.
Thank you. All right, so this is for you, Gopal. As district attorney, how will you balance the operational need to participate in joint federal task force with your duty to maintain local autonomy? Specifically, how will you ensure that cooperation with federal agencies, including ICE and DHS, does not compromise California state law or civil liberties of Alameda County residents?
So when it comes to the immigration, it is very real. I started my law practice with the immigration. I'm an immigrant myself, and I have seen the whole journey. I have seen the fear. I have seen the green card. They have the fear as well. Sometimes they block my time 2 in the morning because their parents are coming and they are not sure about that. And that's the reason I have a policy that the no ICE. That means I will follow the sanctuary state law. Alameda County, they have their own rules as well. My office as a district attorney will not cooperate with the ICE unless it is legally required, and it will be limited to that and that specific requirement only. My district attorney office will not be used as a tool by the federal government. I am with the Alameda County. I'm with the people of the Alameda County. All it matters is the justice and peace and the safety in Alameda County.
Thank you. Ms. Price.
The question is a bit confusing because our coordination is with the Department of Justice attorneys. We don't go directly with the federal, like the ICE or the Custom and Border Patrol or the DHS agents in task forces by which we participate directly. Our inspectors division is limited to actually working on the cases that we are prosecuting. And so our cooperation under my administration was with the Department of Justice, where we were working on human trafficking, okay? And in that context, what we were very clear about was we were not going to use, number one, we were going to protect immigrant victims because that was what, as a mandate that we understood we had, and that we were not going to use people's immigration status in the context of charging or plea bargains to increase the penalties for that. So that our office had adopted the sanctuary policy and the immigration protection policy.
Thank you. Ms. Jones-Dixon.
So we follow the California Values Act. We do not engage with ICE. We don't provide information to ICE. Again, I think it's concerning to me that that we're in a position where we're having a conversation about task force with, like I'm looking at the city of Oakland right now is involved in a task force with the feds to tamp down gun violence. That's been happening forever. There's nothing new about that, right? Not DHS and ICE, but that is really the DA, the prosecutor to prosecutor relationship, right? If a case comes to us, DOJ to the DA, right? We're not in the weeds with that. But I think that the biggest issue is we also need to realize that we must take into consideration someone's immigration status as it relates to a plea bargain. We find that information out from a defense attorney who comes to us and says, this is my client's status. Can we get a better deal on this case because it won't affect his immigration status? So I don't want to leave that out. We absolutely do get that information from defense attorneys. We don't seek it out, and we don't provide any information to ICE.
Thank you. No, I do. There is one aspect that I think Ms. Price brought up, and perhaps I'll ask her. The human trafficking, for example, where individuals are brought to the United States from other countries, that does involve Department of Homeland Security, which also falls under DOJ. So when it comes to the task force aspect of cooperating, what can you tell the residents of Alameda County about the contours of this relationship with that task force? Because these joint task force are very much a part of every aspect, seemingly for organized crime. They're necessary. So if you could kind of provide some feedback about your participation in joint task force work, especially related to human trafficking with Homeland Security, and how you are able to safeguard civil liberties.
Sure. When we worked both with the FBI, and they did a number of operations which our office participated in, and we made sure that to the extent that those persons were coming to, number one, our Victim Advocates Division, because that was our primary contact with those who were being rescued or being identified in that we were providing services, that there was a backlog of U visas, and we cleaned that up, and we made sure that we provided access to U visas to protect victims. Sorry.
Would either of you like to respond? I'll start with Ms. Jones-Dixon.
So when I first got into the seat, I was very concerned about what was going on with the feds. And I sit at the ACBA meeting, which is the police chief's organization, and you could feel the chill in the room because the feds are in the room. And so I have not actively been involved at this point in task force with the feds until I can get a feel for what exactly is going on. I don't want to inadvertently put someone in harm's way. So we are not currently involved in task force as it relates to human trafficking with the feds.
Thank you. Go, Paul.
Sure. Not too long ago, I have a report that the district attorney office was using the immigration status of the defendant to force a plea deal on the person. This policy has been stopped now. As my district attorney, when I become the district attorney, this will stop for good. I'm not here to use somebody else's immigration status to force them for a plea bargain or to force them for the jail time or anything else.
Thank you. All right, so now we are on to Ms. Price, correct? What issues arise in handling cases involving transgender or transitioning witnesses, victims, and defendants? What training or strategies can be implemented to ensure that proper sensitivity is used during the investigation and in front of the jury if the case goes to trial?
One of the things that we were able to do after about a year of research and conversations with other district attorneys around the country was to create a gender justice division in the DA's office. And the person that I appointed to head that up not only was the former district attorney of the island of Kauai, but also someone who is transgender. We had a number of folks in our office that were in our leadership that in fact identify as transgender or LGBTQ+. We were developing, of course, one of the things that we know about when you're looking at a jury trial and you're addressing a person, whether a defendant or the victim, is that you don't misgender them. And that policy was in the process of being developed and it's very clear, but it's not something that our deputies were trained on. The deputies need more training on how to address those issues. And I think that you need to have people in place who are sensitive to the issues, who understand why it matters.
Thank you.
Thank you.
Thank you. So the lawyers, they have the habit to make it complicated. The law was designed by the people, for the people, and these are the people. So we have to, first of all, recognize that yes, they have the right, they have the fundamental right to identify themselves. And we have to be sensitive about that. We have to honor that, we have to respect that. If somebody wants to call him, her, they, we should respect that. Okay. As a district attorney, and plus in my practice, I have this. I ask each and every person what pronoun they want to use. And I have all my staff instructed, clear instructions that we should have the preferred pronoun in the intake form. It is more about recognizing that and respecting that. It is not that complicated. As long as we have the clear guidelines, a little bit of training, it can be handled. Don't make it complicated.
Thank you.
Thank you.
Ms. Jones-Dixon.
Thank you. So the question, the way it's written, is regarding investigation and in front of a jury. District Attorney's Office oftentimes is not involved in the investigation, so I'm going to take that out of it. The DA's office, of course, is involved in trials. And so a big piece of this is we voir dire, we ask questions of the prospective jurors. And we do that, we're trained to do that. We have a lot of training about how to do that and to make sure that there's no bias in that jury pool against anyone. So you ask people what their issues are with LGBTQIA+ folks, if any, if that's somebody who's a witness or a victim. And if somebody identifies that bias, then they cannot be on the jury. So it is pretty straightforward. And of course, there's always training within the office to make sure that people are being respectful of everyone in the community.
Does anybody want to respond? All right. Well,
Sure.
you want to use?
Yeah, I have to disagree with my successor because one of the issues that we found when we exposed the death penalty cases was that the office did have a practice of being very derogatory towards LGBTQ+ persons, and that we recognized that there needed to be far more training and recognition amongst the deputies. And that again was one of the projects on tap for the Gender Justice Bureau. You have to be able to identify the problem and then have specific policies and procedures to address it. So I think that remains to be done.
I do want to push back a little bit on this, the bureau that you were talking about and trainings. With the budget constraints, we're hearing that there was a budget shortfall. Where exactly will you be looking to find the funding for trainings and joining these various task force and joint LGBTQIA+ organizations or prosecuting organizations?
Yeah, we weren't joining task force. We had our own bureau, and there was no budget shortfalls as alleged here. Those are vague allegations. I can assure you, we put in a budget 2 years in a row, and we didn't have any problems with that budget. And if we had, the county administrator, Ms. Susan Maranishi, would have had a conversation with me. That conversation never happened. So it's easy to make, vague allegations of financial mismanagement when there's no transparency.
Thank you. Would either of you like to respond?
And I'm sorry. I hired.
We already heard that you hired somebody. Ms. Jones-Dixon.
So a couple of things. I want to start with that budget comment. I can only tell you that the state of California, I have the bills on my desk. We had to come up with the money that was not paid to the state of California and also come up with the money that was not paid to the folks who were seeking to send us to collections. Now, just because you can find a way to get a budget through doesn't mean that that's not the case. And so as we deal with the state has almost taken our grant opportunities as it relates to insurance fraud specifically from us. We had to beg and plead to keep it as a result of that.
Thank you. Paul?
Yes. We have one district attorney office in Alameda County, only one. There is no second district attorney office. We cannot go to some other county. And all I see, there is a budget problem, there is this problem. We can always brag about that there is a reason, and because of that reason, we are not able to deliver the results. We need to have a district attorney office based on the outcome, based on the results, not on excuses. We can use all our contacts. If something is not working, change it, replace it, fix it.
Thank you. All right, so You're up. Victims' rights. How do you weigh victims' rights against rehabilitation?
So I don't think you weigh them against one another. I think they're both extremely important. And I think that's kind of the problem, that we're quick to say one is more important than the other. Both entail or have constitutional rights attached to them. I think that it's just as important to make sure that victims' rights are adhered to as it is to make sure that we have fair and impartial processes in place for those who are accused with a crime. So I don't see it as weighing. I see it as a huge obligation on behalf of the district attorney and as well as the county to make sure that both are taken care of.
Thank you. Ms. Price.
I agree that with my successor, it's not an either or. You don't put those things against each other. You have to accomplish both. The district attorney does not represent the victims. The district attorney does not represent the defendants. The district attorney represents the state of California, and we have a duty to ensure justice for anyone who is impacted by the system. We are the impartial person that's supposed to make sure that justice is done. And one of the opportunities that we have to protect public safety is to help to be engaged in the rehabilitation process actually before people come home, because it needs rehabilitation and reentry starts before they're released. And that's one of the things that we did with our reentry unit, was focus on how is this person being prepared to come home. We did communicate with victims, and every victim is different. People have different views about what they want to have happen.
Thank you.
Thank you.
Go, Paul.
Thank you. Sometimes we say things, but we don't do those. So there was a case, Radius Recycling, and the current district attorney office took that case off, got it dismissed. It was a $33 million lawsuit. So I don't see this is helping the victims. That's the reason. I have another district attorney not able to recognize that victims are the backbone of our business. District attorney office is basically a place of business. We get funding, we have cases, and the victims, we have to work for that. So we have to recognize that. If we are not able to recognize that, we cannot deliver the outcome. We are not working for the defendants. We are not working for the judges. We are working for the community. Community means who has the problem. The person who's going to come to us, that person gives us a job. Then we actually find a person, we arrest that person, we prosecute that person. If we don't recognize that, we cannot do that. That being said,
thank you. You can use, if you'd like to use your one of your rebuttals to continue.
Sure.
Go ahead.
That being said, the victims' rights are way more important than the rehabilitation. I support both, but not at the cost of victims' right. Thank you.
Thank you. Does anybody, I think you've used your 3.
Oh, okay.
So
I have none.
you've got, if you'd like to.
So a couple of things. One, I find it fascinating when people who've never practiced criminal law tell us about what we can prove beyond a reasonable doubt. And it seems clear to me that there has been this period of time where we've had multiple people having conversations about what we do for a living, yet knowing nothing about it. There have been so many cases charged under the last administration we couldn't prove beyond a reasonable doubt. Right? Probably has a lot to do with people not knowing how to do this work and folks who have never touched the penal code. So for me, it is very infuriating to have that conversation.
Do I have another rebuttal left or no?
I am curious to know how the conversation with the victims of cases that are getting dismissed, how do you approach those conversations? Because it must be difficult if I could hear from
Absolutely. I spend a lot of time, day after day, sitting with victims' families, and who feel like they were not heard, and they were ignored, and they were mistreated. Sometimes those conversations end in tears. Sometimes there's some level of closure around it. But the goal is to make sure that people know that they are heard. and that we can make promises about how we move forward. I can't change what happened before I got here, but I can make a commitment that if we can prove a case beyond a reasonable doubt, we're going to go after it, and we will support victims.
Gopal.
About the criminal practice, I don't know where the data is. I think my website is doing the marketing in a very good way because I have very specific, I told you I'm a very successful business person. I have focused marketing, and because of that, the people, they think I don't have any criminal law practice. I do. I have done cases in Alameda County. You can search my name. I have done cases in Fresno. I have done cases in Santa Clara County. So I do practice. I don't prefer to market.
Ms. Price.
Miss Addie Kitchen, whose grandson's murder case was dismissed by this district attorney, has endorsed me, and she does not believe that she was heard by this office, and there was sufficient evidence, in my view, to charge and convict Officer Fletcher. And I also need to clarify, we did not have inexperienced people charging cases in Alameda County under my administration. We had 36 lawyers charging cases in Alameda County. All of them were from the prior administration under Nancy O'Malley. They were
Thank
all
you.
experienced lawyers.
Would you like to briefly respond, Ms. Jones-Dixon?
Sure. I would just say this. What I do is adhere to Marcy's Law. I can't give every victim everything they want. And a lot of victims walk away from the criminal justice system feeling like they're not whole, because they never will be. That's not, we can't get there.
Thank you. All right, we're going to move to Gopal. I believe it's you, sir? Can you explain what the role of deferred entry of judgment can have on reducing incarceration?
The role of the district attorney is not to fill the prison. It is to provide justice. The punishment does not mean prison. You can punish a person by so many ways. You can give them work. You can take the credit away. There are so many ways. This is America. You can hurt a person by just muting the mic. Simple way. Or not recording that. The deferred entry of judgment is a pilot program, and it was a pilot program, and it was very successful. And I prefer that. It helps the defendants. It gives them a chance to reset the whole life. As long as they are doing it in a proper way and it is judicially supervised, yes, it is a very good tool to reduce the prison population. It also helps the families. I have seen in my practice, because of that, there are many families, they are together. They have kids together. And because of the deferred entry of judgment.
Thank you. Ms. Jones-Dixon.
So deferred entry of judgment is not a pilot program. It's a statute. It does, in fact, make sure that people are not in custody. If you defer their entry of judgment, then they can stay out of custody, do certain things that are asked of them by the court. And if they're successful, then that case goes away. So by definition, it helps to reduce incarceration. It's pretty straightforward. And it's not the only thing that reduces incarceration. There are many diversion programs where we're able to do that as well. Some of those are PS program. We have mental health diversion. There are all kinds of diversion programs that can keep people out of custody and steer them away from the criminal justice system.
Thank you. Ms. Price.
Sure, the deferred entry of judgment is exactly that. A person who is facing potentially criminal penalties is given the opportunity through the court to complete a program or they don't necessarily have to go to a program. Sometimes they do, sometimes they don't. They're not normally judicially supervised, but they are allowed to go and do things that indicate that they are not going to cause problems in our community. And then after that, if they, through a certain period of time, then there's no criminal sentence imposed. And so it does automatically.
Oh, sorry.
Yeah, no, it does automatically reduce incarceration and provide an alternative to incarceration.
Thank you, and my apologies for interrupting.
That's okay.
And you're next, actually. How will your office navigate the complex interplay between rehabilitative misdemeanor-focused goals of Prop 47 and the stricter felony penalties for repeat theft and drug offenses recently mandated by voters under Prop 36.
Yeah. I think I recognize that Prop 36 was passed by the state. Roughly 62% of our voters voted yes on Prop 36, and it is the law now. It is a bad law, and I opposed it, and I will continue to say it's a bad law. It undermines what we previously tried to achieve under Prop 47, which was to reduce penalties as well as a whole slew of legislation. What is critical now, the one thing I do agree with in Prop 36 is the stricter penalties for fentanyl, because it is a very, very dangerous drug, and we were doing what we could. Before Prop 36 was passed, we issued the Watson-style admonitions to people. We actually used one of our funds, some of the funds that we do have available, and sent out mailers to people telling them, if you sell fentanyl and it results in the death of someone, then you will be prosecuted for murder. And that's the thing. I do agree that that should continue to happen.
Thank you. Ms. Jones-Dixon.
So agreeing that Prop 36 is clearly the law, I think our biggest concern is there's more data to be had to see how successful it is. And the bigger piece is I think the county has to invest in more treatment, but that's across the board for all kinds of things. But if we don't have the treatment and we're charging the Prop 36 cases, that's not exactly what it was meant to do, right? So I think for us, we're looking to always adjust to what the data is. And right now, there's not a whole lot of data for this county. That has some to do with the fact that we had stopped charging a bunch of crimes, petty thefts and smaller thefts years ago. But we are looking at what the statistics look like to see how we can better push our county and maybe the state to get the treatment necessary that goes along with Prop 36.
Thank you. Go, Paul.
Thank you. So Prop 47, it was very good, awesome. But it was not perfect. No law is perfect, actually. That's the reason the lawyers, they keep practicing. It's a practice of law. We cannot perfect it. And the 36 came into the picture to make some changes in it. And I'm not saying, okay, there will be no other bill to reform the 47 and 36. But when it comes to the current law, yes, there is a current law. And as a district attorney, I have to follow the current law. I have to respect the voters' opinion. There is nothing I can do about it. One of the things is it matches with my priorities, because I'm gonna be tough on organized crime, retail theft, repeated offenses. They are most of the time tied with the organized crime, with the repeated offenses. So I welcome that part of it. Same thing for the drug offenses. We can make some leeway for the offenders based on the provisions.
Thank you. We have to move on.
Yes, we do.
No.
Who's next? Give me a moment, please. Yes. Oh, okay. I see. So who is it? Jones-Dixon? Apparently I skipped one. Do you support alternatives to incarceration, and specifically which ones? Would you support alternatives to incarceration even in a case of a serious violent offense? Why or why not?
Yes, I support. And it really is fact specific as to which cases. I think that the first thing I would be looking at is to see if this is a young person, if this is somebody who has prior history, et cetera. But I mean, if we didn't have alternatives to incarceration, I don't see how we move forward in this society. We have way too much crime that we're dealing with for us not to be trying to rehabilitate people and move them away from this system. So yes, I support all of the alternatives to incarceration, all the diversion programs. I was in a collaborative court for 10, or actually 11 of the 11 years I was on the bench. So I was able to sit in those courts and to help move people through those courts and through whatever issues they were having in their lives. So I think that's a huge piece of how we get the community healthy, for lack of a better way to say it.
Go, Paul.
When we say that we have to do this or we don't support that, it is an extreme. So as a district attorney, whenever you have any approach which is extreme and there is no leeway, that's not a good approach. So when I say, okay, do I support incarceration or not? So there are very specific policy I have. So if it is a first-time offender, non-violent, then yes, I can see the reform in it. But if it is a repeated offender and it's a violent crime, they will go to prison.
Thank you. Ms. Price.
Alameda County has adopted the CARES First Jails Last policy, and every district attorney should be subscribing to that policy. And we did during my first term, and we will in my second term. What that means is that we expanded the criteria for diversion courts. We opened the floodgates for all of our district attorneys to be able to refer people that they felt it was appropriate to refer to collaborative courts, and then we would deal with it there. So we adopted a dramatic change in policy. Right now, Alameda County and Cal Matters did the study. We are leading the state in Prop 36 charges and prosecutions. And so that is antithetical to the CARES First Jails Last policy of this county. That data is publicly available. And so as a district attorney, again, we have to balance the opportunities for people to be able to have alternatives to incarceration versus the punitive nature of Proposition 36.
Thank you. Gopal. These are questions from that we received from the community. When addressing deeply complex crimes like domestic violence and human trafficking, advocates often argue that traditional prosecution-centered approaches like simply seeking convictions and jail time fail to break the cycle of abuse or adequate support for survivors. As district attorney, how do you view the limitations of a strictly traditional prosecution model in these specific cases? And how will your office allocate resources or collaborate with community agencies to fund prevention, early intervention, and restorative justice models with proven outcomes?
Long question. I got it. So nothing about me is traditional. I don't know have you seen my office or not. The whole office is digital. I don't have one single piece of paper. I can start my office anywhere. So it comes to the resources. How do you allocate the resources? And that comes with efficiency. We need to see the root cause for that. And I can use the data points. I can use the data available. I can use the data from multiple sources, and we can use that to see where do we have to put our money and how do we stop that? Not just one victim. We need to see how the whole chain is working out. When you see the human trafficking is not one person. I deal with the immigration. I know that firsthand. That has to stop. We need to stop the organizer. We need to stop the corporation who is actually funding the whole operation. Once you pinch that, then you can fix it.
Thank you. Ms. Price.
As a domestic violence survivor, I can tell you that the traditional prosecution model does not work, and it has not changed very much since 1981. When I came into this office, it was very clear that we needed to do a much better job of training prosecutors how to talk to, just basically how to talk to survivors of human trafficking and domestic violence. We invested in hiring additional victim advocates and working with programs. We hired the first transgender advocate, and they convened a monthly support group for transgender survivors of crime. We began providing trauma-informed, making sure that we were providing better trauma-informed services, not only for the adults, but for the children who are impacted by that. And we really focused on children under my administration. We focused on healing and tried to make sure that we were improving the services of delivery through the Victim Services, the Advocates Division.
Thank you.
Thank you.
Ms. Jones-Dixon.
Alameda County was the lead in the state and one of the leads in the entire country as it relates to human trafficking cases. Well known. And so the way we spoke with victims, me included, because I tried those cases, and I also was a judge handling some of the young women who were moving through our system, I absolutely disagree with that position. The Family Justice Center grew out of the need to help people, specifically victims of domestic violence. It was geared around that, where one person could go into the Family Justice Center and get services if they were the victim of domestic violence. So I take umbrage with that as well. I think that, nothing's traditional anymore. The goal is to try to find a way to make sure that we don't keep doing the same thing over and over again with the same result, which is clearly insanity. Victims' rights that's gonna have to grow and change, just like how we deal with prosecutions. But having those things in place, like the Family Justice Center and a HEAT team, is what we need.
Thank you. So this would be for you, Ms. Price. Although California currently has a moratorium on executions, the death penalty remains the law of the state, and the district attorney's office holds the ultimate authority to seek it in a capital case. What is your position on the death penalty, and will your administration pursue it?
My position on the death penalty is that Alameda County has done a great harm to our county. This district attorney's office, under my predecessors, did a great harm. It was a 30-year pattern of serious prosecutorial misconduct in death penalty cases, using race and religion to exclude jurors. And we exposed that, and that cost us dearly. I am opposed to the death penalty, and we did not initiate the death penalty. As you know, and any lawyer knows, that having a death penalty charge dramatically increases the cost of the defense and the cost to the court. And so we should not be engaging in that. And it's the final ultimate penalty. And so this office has had such a long history of misconduct and discrimination in that area that we really we need reparations to make sure that we get that right. We need to resume the resentencing that we started, that Ms. O'Malley started, and that I continue. Thank you.
Paul.
When we take somebody else's life, that's the maximum punishment we can actually give to that person. And it's not normal. It has to be used in a different way, and it has to be used that because you cannot reverse it ever. So once you are using it, you have to be extremely careful. You have to beyond extreme to measure it when you ask for that. So should we remove it? I would say no. It should be there, but to use it, it should be used in rare cases. We have to have each and every case fact thoroughly see and view and review multiple times and see how does it work. Are we doing a justice to the community? Because we are taking a life, there has to be a very good justification for that. If it is not there, it means we are not ready. We should not be regretting that. We should be able to answer the community that yes, this person deserved to die. If you can convince the community, then yes, you did a good job.
Thank you. Ms. Jones-Dixon.
Under this administration, we are not seeking the death penalty. We have not. I do disagree to some extent with what Ms. Price has said. I think that there have been a lot of concessions made by the prior administration that just aren't necessarily borne out. And I don't like agendas. So especially for a district attorney, I don't think we should be agendized. When we come to the table thinking that we want no death penalty cases and we try to resentence all of them, I think we also need to realize we continue to move the goalposts for victims. We need to be having a conversation with victims who sat through those cases saying, we're going to resentence this, but you get a chance to be a part of this process. And so for me, when I walked in the door, that was the biggest concern about the death penalty cases to me. Many victims came to me and said, we knew nothing about this process. Nobody said anything to us. And that's what we're trying to rectify now.
So I wasn't clear that I heard your response regarding your position with the death penalty.
We do not seek the death penalty in my office, is how I started.
Okay, thank you. So this would be, all right. So as district attorney, what is your policy on integrating artificial intelligence into daily operations of your life? How will you balance the potential for taxpayer savings and workforce reduction against the profound ethical concerns such as algorithmic bias or AI-generated errors impacting a defendant's life and liberty?
I'm not a big fan of AI anyway, so this is an easy one for me. I get a lot of pushback from some of the younger lawyers who want to use certain AI. I think a lot of the police agencies would like to use that technology for police reports. I don't support it. I can't make the call for them. But I just feel like in a position that is so human focused, you need to engage people one-on-one. AI feels uncomfortable to me. I don't ever want to get to a place where we're having a conversation about AI making the call as to how we provide services to the community, whether it be victims or those charged with crime. So I am resistant in a lot of ways to AI, maybe more than people who work for me would like.
But what about staffing, for example?
I mean, from my perspective, how do you use AI in a DA's office? We are people who deal with individuals every day. Like, I just don't see the road for that, and I don't support it. So I want people to be working with people. I think victims deserve that, and people charged with crimes deserve that. And from a staffing perspective, I'd rather us have a budget to hire people than use AI.
Ms. Price?
During my time as your district attorney, I've participated in numerous conversations at the county level. The county has an AI policy. It's not something that the district attorney unilaterally decides we're going to do this or we're not going to do this. It is something that is jointly developed with all of the agencies in the county. And those discussions were ongoing. The opportunity for utilizing AI, I think there are opportunities where it would facilitate the prosecutorial process. For instance, I can imagine a situation where we could have, as part of our CRIMS network, which is a database, that we could have that, use that to identify police reports where insufficient information is there for prosecutors, okay? Because a lot of times we get reports that they haven't filled in all the forms, and you have to go back and it delays the process and the case gets continued and it slows everything down. And so there are particular, I think, functions of AI, and we had a great technology team.
Thank you.
Thank you.
Go, Paul.
I believe the question wasn't prepared by any engineer. I can see that. This is AI bias is the first time I heard. AI error, yeah, they're very common. It's not a new technology. We have the AI everywhere. When we book the hotel, when we book the air ticket, when we go somewhere, there is AI everywhere. We cannot have the district attorney office technologically challenged. We have to use the AI. AI is not a governor. AI is not, it is just an assistant. It does things in a faster way, in an efficient way, but it doesn't replace human. It gives you the data, which regular computer will take a lot of time. So yes, you can, and it compiles in a very good way. You can talk to that person. So this is not replacing a person, this is helping a person. So I support the AI. For the errors, yes, there has to be human, just like any other assistant. You cannot just ignore the AI. It is a highly developed processing unit. And in the district attorney office, you can have the custom large language models.
Thank you. Okay, so this is the end question that was provided, I believe. So we'll start with Gopal. In one sentence, what specifically differentiates you from your opponents?
Sure. I'm not going to talk about the gender,
You can use a semicolon.
but I'm the only candidate who hasn't received any money from any police chief or any law enforcement officer. And I'm the only person who has been through the whole immigration system. And I'm the only person who is making my life based on the regular people. I'm not tied with any government. I'm not tied with the district attorney office. I don't owe anything to any county office or any government. I'm here to help people.
Okay, appreciate that. Ms. Price.
I'm the only one in this race that has decades of community service, of representing everyday people in their worst moment, representing victims, holding corporate criminals accountable, a diverse practice, and then bringing that knowledge and my experience, my lived experience as a survivor into the office and recognizing the importance of providing quality services for victims and making sure that our prosecution is fair and that has a lens that we are going to ensure we're going to root out the racial and gender inequities in this system.
Thank you.
I'm going to try to keep it to one sentence. I think I have the unique experience of both a prosecutor and judge, the managerial experience and ability to organize a large organization such as the DA's office, and I'm not agendized. I think those are the three most important things.
Thank you. And now you guys will have, I believe, 30 seconds for closing statements. Yes. Oh, that's it? Oh, well, then thank you. Thank you. Thank you guys for your participation. I want to thank the candidates. I want to thank ACBA. I want to thank the League of Women Voters for their support and for helping, being a tremendous support for this. And that concludes this evening's presentation.
Thank you.